Lisa with Family Matters Law Group. So oftentimes we have clients who hire us and we explain to them that while we don't use the word custody in Florida, we do have kind of two concepts, time sharing and parental responsibility. So when it comes to making decisions about kids, that falls under the category of parental responsibility. And there are three options in Florida. The first is shared parental responsibility. Shared parental responsibility means that the two parents are going to cooperate and collaborate in making any kinds of decisions as it pertains to the kids. 99% of the time, parents end up with shared parental responsibility. Okay, so perhaps 99 is a little bit of an overestimation, but I want to drive the point home that most cases end up with shared parental responsibility. It's only in cases where it would be detrimental to the child for there to be shared parental responsibility that you would end up with either what we call ultimate decision making or sole parental responsibility. Sole parental responsibility means that one of the two parents is making the decisions, and ultimate decision making means that the parents are going to cooperate, collaborate, try to talk about the decisions that need to be made, and if they're not able to make the decision, then one parent ultimately will have the final say. So what happens when you have shared parental responsibility and you don't agree? You end up having to go to court. With ultimate decision making, when you have parents that don't agree, one parent has the final say in what's going to happen. It is very rare that our courts will enter orders for ultimate decision making or for sole parental responsibility. It's typically in cases where one parent has some sort of impaired judgment, or the parents have such an inability to cooperate and to connect with one another that one person really needs to be in charge. It's a really hard thing to prove. It's something that doesn't come easily in most cases, and it is by far the exception, not the rule. When it comes to time sharing in Florida, most parents, there's this concept that, hey, everybody has 50-50. Parents don't necessarily all have 50-50, and our law doesn't say that the parents are going to have 50-50, but depending on what county you're in, there can be a very strong presumption towards 50-50 time sharing. Now, when it comes to overnight visits, sometimes we have moms telling us, well, my child's so young, I don't want the child to stay with dad until the child is older. We don't have those kinds of laws anymore in Florida. There's a presumption that parents are going to spend a significant amount of time with their children, that both parents are going to be able to overnight parent the children, take the children to school, and in a lot of instances, share the kids equally. So it's really kind of an exception to the rule to do something other than that. It's certainly more common for us to have like a 60-40 split or a 70-30 split. It's fairly uncommon for us to end up with a parent who doesn't have overnights, and it's very uncommon for a parent to end up with supervised unless something really serious has happened that's put the child in danger or in harm's way. If you have more questions about these kinds of concepts or want to talk about your case, get in touch with our firm.